One of the major types of insurance that is required by construction contracts is CGL insurance. And CGL just refers to commercial general liability insurance. It used to be called comprehensive general liability insurance, but the insurance industry thought that sounded like it provided maybe more protection than it really was comfortable with. And so the lingo now is commercial general liability insurance, but everyone just refers to it as CGL. Now, all types of businesses have CGL insurance because what it's designed to do is to protect the insured against liability to third parties as a result of accidents. Now, it's more complicated than that, but that's the basic concept. You have a business, members of the public are coming and going, for example, and people slip and fall, or they otherwise get injured, or their property gets damaged. And so CGL insurance is something that you find in all sorts of businesses, including construction businesses. As I say, it's classic, what's known as third-party insurance. That is to say, where the insurance is designed to protect the insured from claims by third parties, that is, strangers to the insurance contract itself, where the third parties allege some sort of bodily injury or property damage that's due to a covered, quote, occurrence. Now, we'll unpack that a little bit, but the basic concept behind an occurrence is when you see occurrence, think accident. It's actually more subtle than that, but for our purposes, it's worth having that in mind as the sort of guiding idea behind CGL insurance. When there's an accident that injures some third party, that is not the insured and not the insurance company issuing the policy, but some third party, CGL insurance is likely implicated. Now, the AIA forms require all three of the major players, architect, owner, and contractor, to carry CGL insurance. And I've given you in the slide the specific sections out of the B101, A101 that are relevant here. The A101, the main owner-contractor agreement, where the price is based on a stipulated sum, has its separate exhibit just for insurance, Exhibit A. It's very long, and it's worth having a look because it spells out exactly what kind of insurance the different parties have to carry. Now, the key provisions of a CGL policy are the ones that I've listed here in the slide. This is under what's known as the ISO form. And ISO just stands for Insurance Services Organization, but everyone just refers to it as ISO. It's an independent outfit that produces form insurance policies that are widely used in the industry, again, not just in the construction industry, but in commercial businesses generally. And in fact, there are whole databases in Westlaw devoted to collecting decisions of different courts around the country in the United States, interpreting the different provisions of the different ISO policies. And for anyone who ends up going into any sort of insurance defense work, a lot of the work will end up being questions under CGL policies, and many times these are ISO forms. So what's generally true is that there are in CGL policies, and certainly including the ones in the ISO forms, the main area where what the insured is getting covered for is defined in these different coverage sections. And the main one is coverage A, which covers bodily injury and property damage liability, right? Exactly the things that I was talking about. This is the sort of classic case of what a CGL policy is designed to cover, bodily injury and property damage. Some of the other coverage provisions include things such as advertising injury. We're not going to go into those. I just want you to understand the main points that a CGL policy is designed to cover. Now, within coverage A, you'll notice that I have in quotation marks here, legally obligated, bodily injury, property damage, occurrence, etc. These are all defined terms. And part of the challenge in understanding an insurance policy is to be able to read the coverage provisions in light of the definitions that are provided in the insurance policy itself. So for example, legally obligated, that's a defined term. And so in order to understand exactly what coverage A covers, you have to have one hand on the definitions section and another on the coverage section so that you can read what legally obligated means at the same time you're reading the coverage provision, because it's sometimes the case that the coverage provision giveth, but the definition taketh away in some fashion. Same thing with bodily injury, same thing with property damage, same thing with occurrence. These aren't terms that you can just assume you know what they mean. What the practice is, and what a court will do, is look at the coverage provision in light of how, what the policy itself has defined counts as a bodily injury, or what counts as property damage, or what counts as an occurrence. And these are highly complex documents, insurance policies, but the starting point is just to read the coverage provision, understanding that it's going to use a lot of defined terms. Then you have to go back, look at the defined terms, and sort of annotate the coverage in light of the defined terms that the policy uses. Okay, in addition to the coverage provisions and the definitions that it uses, there are going to be exclusions. And some of the main exclusions under coverage A, for example, the expected or intended injury exclusion. The concept here is simply that, okay, if somebody gets injured as a result of an occurrence, okay, but there was some intentional, some intent on the part of the insured, for example, to injure the third party, well, that's going to be excluded from coverage, even though a literal reading of the coverage provision might suggest that it would be covered. In fact, that's excluded. Contractual liability, likewise, with certain exceptions. Simply being liable under some other contract generally is not going to amount to a, quote, occurrence that will trigger coverage under coverage A. Employer's liability, pollution, damage, all these exclusions have a whole body of case law that's grown up around them, as well as having fairly complicated and detailed exceptions and policy language in the exclusions themselves. So after establishing kind of a tentative conclusion that something may be covered, the next step is figuring out, okay, is there an exclusion that might apply that would, again, take away the coverage? And within exclusions, to make matters even more complicated, there are often exceptions. So an exception to an exclusion can restore coverage. So if you've got coverage, but it's subject to an exclusion, but then there's an exception to that exclusion, the net result may be, in fact, there is coverage. So this is just the most superficial examination of CGL insurance. Understand that CGL insurance is ubiquitous in the commercial world, including construction projects. Everybody carries it. Everybody wants everyone else to carry it. And the basic concept behind CGL insurance is to protect the insured and others with whom the insured is in some sort of contractual relationship against claims from third parties for bodily injury or property damage as a result of some fortuitous event, some sort of accident that nobody anticipated. The central case where there's coverage under a CGL policy is where somebody gets injured and it's not, the cause of the injury is not a business risk that the insured had is legitimately supposed to be managing on its own.